The high-profile trial of the three men accused of killing Ahmaud Arbery is in its fourth day today. Yesterday, Glynn County police officer Jeff Brandenberry testified that Greg McMichael, one of the three men on trial, said he believed Arbery was responsible for break-ins in the neighborhood. According to a transcript of body cam video from the incident, McMichael told police he was not sure if Arbery was armed the moment the three white men hunted him down. Greg McMichael, his son Travis, and their neighbor William Roddy Bryan are all facing murder charges. Rikki Klieman joins us now to discuss. Rikki, it's good to see you. So during Officer Brandenberry's testimony yesterday, he revealed that Greg McMichael never said he was trying to make a citizen's arrest. What do you make of the prosecutor's strategy to weaken the defense's claim that the three men were attempting to detain Arbery for police?
In Georgia, at the time of the killing of Ahmaud Arbery, there was a law in place that had to do with the right of a citizen to make an arrest. So the defense is saying, look, we have this right. We're really here trying to protect our neighborhood, and the law sanctions that. And it was in the course of our making this arrest, in the course of detaining Ahmaud Arbery, that this terrible tragedy occurred. That's the defense. Now, the prosecution has the burden of proof. So what the prosecution is trying to say is that, well, if you thought you were making a citizen's arrest, if you thought you were detaining this person under law that allowed you to do this, well, why wouldn't you have said that to the police as soon as they showed up? It's a good tactic for the prosecution, there is no doubt.
So as you point out, this citizen's arrest law in Georgia has actually since been repealed as a result of this very case. But at the time when it was in place, can you just explain what a citizen's arrest law is? Because I honest to goodness thought that the concept of a citizen's arrest was a myth. I didn't actually realize that it was actually sort of on the books in some places.
Well, actually, it's on the books in most places. Georgia is the first state, as a result of the killing of Ahmaud Arbery, to actually repeal such a law. The law in Georgia at the time of the shooting of Ahmaud Arbery said that a citizen had the right to make an arrest of another citizen if one of two things happened. Number one, a crime was committed in that citizen's presence. That is not what happened here. Or that the citizen, I want to get the words exactly right, it was in the citizen's immediate knowledge of a law being broken. And the citizen had the right that if it was a felony, that someone who was escaping or attempting to escape, that the citizen had a right to go forward and arrest them and detain them. This is not an uncommon law, though I agree with you, Anne Marie, most of us would have thought it was a myth. So as a result of the Arbery shooting, some 15 months after the shooting, the Georgia legislature, also with the auspices of the governor, repealed this law. And what they've left are things that we would expect. If you are a shopkeeper and you see someone shoplifting, that you have a right to detain them. If you're a restaurant owner, a restaurant worker, and you see someone who is doing what we call the old dine and dash, that is, you have your meal and you run out the door, you would have a right to detain that person. But with those narrow exceptions, the law is gone. The difficulty, because we always have to keep this in mind, that since it was repealed as a result of the shooting of Ahmaud Arbery, does that mean that because the law was in full force in effect, that it really did create an atmosphere that would give some justification to these three defendants? So the prosecution has got to work hard here to show that they really weren't trying to arrest him. They were just out there in the worst possible way of three white people pursuing a black man who was doing nothing more than jogging peacefully in a neighborhood.
So, Rikki, during Brandenberry's testimony, prosecutors asked him to recall parts of his conversation with Greg McMichael at the scene of the shooting. Here's a bit of what the officer said McMichael told him.
I saw him, yeah. In fact, if if, to be perfectly honest with you, if I could have got a shot at the guy, I'd have shot him myself, because he was that violently, and then we were interrupted again.
So Brandon Barry's testimony supports police body cam transcripts from the scene. What impact did the statement have on the jury?
Well, the impact of someone who isn't the shooter, but that his son was the shooter, of saying, look, I would have been the shooter because this guy was out of control. This guy was acting violently. And then you, of course, see the body cam video. You see the video that was taken by the third defendant, Mr. Bryan. And it will be up to the jury to decide if he was acting violently or he was simply jogging in the neighborhood. Ultimately, you have two defenses here. We can't forget that there are two halves to this defense. One is we three, or at least we two McMichaels, Bryan coming on with them, had the right to make a citizen's arrest. And then, according to the defense, it was because Arbery, the victim, charged at Travis McMichael, who had the gun, that it became an act of self-defense. So self-defense plus citizen's arrest. So when you've got two defenses going on at once, which support each other, they're not contradictory, you've got a big burden for the prosecution to prove beyond a reasonable doubt that this was vigilante action and that these three people did not act in self-defense.
That's really illuminating. Do you have any other sort of big takeaways from the trial so far?
Well, I think the big takeaways in the trial for me are how horrific this case really was. That once you see a smidgen of a video, which we all probably saw during the news coverage at the time of the original horrific killing, that when you see it from various angles, and when you see the intensity of what happened during this chase, that there has to be an enormous emotional context that's going on in front of this jury. Also, you've got really contentious behavior on the part of the lawyers. And the judge actually had to reprimand one of the defense lawyers yesterday. It was just very uncomfortable. So you've got good lawyering on both sides. But this isn't about good lawyering for the public. It may be about good lawyering for someone like me who looks at it from the point of view as an attorney. This is a question of what is ultimately justice under the law of Georgia as it existed at the time of this terrible tragedy.
So let's discuss the jury for a moment, Rikki. There are 11 white women, 3 white men, and 1 black man. Now, this has sparked outrage among some activists and supporters of the Arbery family. If you were a prosecutor of this trial, would you be concerned with the makeup of the jury?
Well, I think if I were prosecuting this case, that of course I would have wanted to have had more people of color on the jury. That's an obvious conclusion. Nevertheless, I have to believe, as you look at this prosecutor, this very talented female prosecutor who is white, who is outraged, why should she not expect that citizens who will take their oaths as jurors seriously, white, black, brown, or yellow, that you would look at this case by the facts that are really shown to the jury? You know, it's the old story that black jurors would be prone to acquittal if you had a situation involving a black defendant. So the extrapolation is that white jurors are going to be prone to acquittal because these are 3 white defendants. Well, I think if you asked many a black person, many a white person, if they looked at this evidence, what would they conclude? And one of the things that certainly comes to mind is either you buy into that defense or what you really are seeing here is a modern day version of a slave patrol. It's a very disturbing case. It
certainly is. Let's not forget the defense lawyer said that he wanted more Joe Six-Packs and Bubba's on the jury, I believe. That's what he said. And the fact that he said that so openly, I think, was stunning to me, Rikki. I don't know about you.
Well, if it was meant to be funny and have some levity, it was not funny. I think what he was trying to say is that we would all like to have a jury of our peers. So does that mean that your peers are just like you are? It's so interesting in this case that the entire idea of challenging the other side for discrimination in their striking of jurors because of race, that was always there to be able to protect against striking Black jurors when you had a prosecution that was striking them. Here, it's been turned inside out. And what you have are 3 white defendants who claim to be worried that they will not get a jury of their peers. Well, look, since time immemorial in this country, when we've been able to have a jury of 12 people who sit on a felony case, you get men, you get women, you get old people, you get young people, you get people of all colors, you get people of all races. They are considered under the law a jury of your peers. You do not have to ask for a jury of your peers that look and sound and were raised exactly like you.
Right. Rikki, really glad we got an opportunity to catch up with you on this case. Thank you so much.
It's always great to be with both of you.